Gail, can you hear me?
I can hear you, yes.
Oh, okay.
I think Gail is still connecting to audio.
Oh, okay. Gail, can you hear me? I can hear you, yes. We will start in just 1 minute. I think we can start now. Oh, Gail is not unmuted. Can you hear me?
I can hear you, but her audio is not connected. Gail, if you see anything on your end to connect your audio, I'll try chatting her actually. Maybe that will be better.
Okay. I'll give it about 30 seconds and then I'll start the program. Did Gail get unmuted?
Yes, Gail,
Oh, okay.
Thank
you.
Okay, terrific. Okay, so we can start now, and thank you very much. Good evening, ladies and gentlemen. Welcome to the May meeting of CB8's Women and Families Committee. I'm Peggy Price. I'm co-chairing tonight's forum with my colleague Gail Barron. In a minute, Gail will fill you in on tonight's program about the battle to preserve access to abortion pill mifepristone. But let me just note that what we're addressing tonight, access to abortion, is a cornerstone of women's rights overall. These rights are under threat from a minority of Americans, but they jeopardize the rights of all of us. Fortunately, people are fighting back, and tonight we'll hear how that battle is likely to play out and hopefully what we can do to protect this basic right that the majority of Americans support. So now Gail Barron will fill you in on tonight's program and introduce our distinguished speakers. Gail?
Thank you, Peggy. As Peggy explained, our forum tonight is going to address the battle over the abortion pill mifepristone. In way of background, last month, 2 federal judges issued conflicting rulings on this abortion drug, and it sets the stage for a clash which might end up in the Supreme Court. First, a judge in Texas ruled that mifepristone would be banned nationwide in 7 days. Then a judge in Washington state ordered the FDA not to make any changes to the availability of the drug, which the agency had approved for use more than 2 decades ago. While the legal process plays out, both abortion providers and health professionals are caught in limbo. This exacerbates the challenges that they have faced since the Dobbs decision. We're fortunate to have 3 very outstanding speakers who are going to address this timely issue. Before I introduce them, Saida, could you just quickly go over some housekeeping rules?
Absolutely. Good evening, everyone. A few notes for you, particularly if this is your first meeting with us. You'll notice that you're muted and unable to mute yourself. Unmute yourself, excuse me. After every presentation, the co-chairs will call on members of the public who wish to speak, and you can ask to be recognized by raising your virtual hand. You can do that by going to the reactions button at the bottom of your screen and selecting raise hand. It's important not to raise your physical hands or wave at the screen because we may not be able to see you among the participants. If you are on a phone, you can raise your hand by pressing *9 and *6 to unmute. Once you're recognized by a co-chair, I'll unmute you and you may be prompted to confirm unmuting on your device. If you're using an older version of Zoom, you can access the raise hand feature by clicking the participants button on the menu at the bottom of your screen and selecting raise hand. The chat function is available for technical support only, not to ask questions of the co-chairs. You can send me a chat if you're having any trouble and I can walk you through any issues you may be having. Gail, Peggy, back to you.
Thank you so much, Saida. As I said, we are really so fortunate to have three fabulous speakers tonight. Our leadoff speaker is going to be Assembly Member Rebecca Seawright. We on the Upper East Side are particularly blessed to have her as our representative in Albany. Rebecca advocates not only for reproductive rights, but for so many other issues across the board. With that said, welcome, Rebecca, and the floor is yours.
Well, thank you, Gail and Peggy, for leading tonight's CB8 meeting and discussion on this very important topic. I'm in Albany. We literally just adjourned about 5 minutes ago, and the speaker called us into immediate conference. So I apologize ahead of time. I'm going to have to jump and run downstairs to conference. We're in the final several weeks of the legislative session. We adjourned for good on June 9th, and we still have a lot of bills to get accomplished. But as the chair of the People with Disabilities Committee, I passed a package of 5 bills yesterday, along with a resolution yesterday and a resolution today. And for People with Disability Awareness Day, and today for autism and dyslexia. And so we, in the final weeks of the session, have a lot of strong support from the speaker, who is a feminist and who is pro-choice. And to the panelists tonight, bringing your special expertise in the field on such an important topic, Susan Appleton and Jenna Lauder. In the Assembly, I'm a member of the Bipartisan Pro-Choice Legislative Caucus. I've been on the phone several times today with Senator Liz Krueger, who's the co-chair of that caucus. And I'm the previous chair of the Women's Task Force here in the legislature. My colleagues and I are incensed by the constant attack on women's bodies and reproductive health care decisions. Over the 20 years ago, mifepristone underwent stringent testing requirements before the FDA approved the medication for distribution on the marketplace. And since then, it has been used safely and effectively along with misoprostol for medicated abortion. It is less invasive than procedural abortion, and studies conducted around the world have found it to be safe and life-saving for those whose health would be greatly compromised by undergoing pregnancy. This ruling is an unprecedented and egregious use of judicial activism. The FDA has overseen determining whether pharmaceuticals are safe since 1938, using evidence-based protocols. So it is deeply concerning that one extreme right-wing activist judge seeks to challenge the FDA's 85-year record of expertise and authority in this area. Although ultimately the U.S. Supreme Court issued a stay and will continue to have the drug available nationwide, the challenges to the U.S. Food and Drug Administration's approval of the medication continues to work through the court system. So the fight is far from being over. The abortion pill increases accessibility of care for individuals who have lower incomes and who live in areas with fewer healthcare providers. Over 50% of abortions are done using medication. This drug is used for managing miscarriage care, and women should not have their reproductive health care options restricted based on their zip codes. So now we stand at a legal crossroads. The court rulings are raising questions not only about the future of the abortion pill, but the federal government's authority to approve and regulate drugs in general. Court challenges open the door for other actors to potentially sue to block the approval of existing or new drugs that may be considered controversial, such as vaccines or treatments for conditions that are at the crosshairs of cultural wars. Manufacturers may be reluctant to bring to market certain new drugs or treatments if they are concerned that a court ruling could block their approval in the future. We have a long and storied history in New York State surrounding abortion. And I remember when my late mentor, Sarah Weddington, who's still the youngest woman to ever argue and win a case, Roe versus Wade, before the United States Supreme Court, came to New York to do her research, her initial research, with a law professor, Cyril Means, before Roe versus Wade. And in 2019, she joined us in the chamber here in New York as we passed the Reproductive Health Act to protect and expand abortion access following 50 years of state reproductive rights. This was a major achievement for New Yorkers. This past January, we passed our legislation. I was the lead sponsor in the Assembly for an expanded Equal Rights Amendment to the New York State Constitution. After voters approve this amendment, which will be on the ballot in November of 2024, our state will finally enshrine equality under the law to prohibit gender-based and sexual discrimination and secure abortion access. Increase reimbursement rates for reproductive health providers, as other states have banned abortion and shut down clinics. New York's reproductive health care system is facing unprecedented pressure. And to address this and make sure all who need reproductive health care can access it, we have increased Medicaid reimbursement rates for health providers. We have worked to expand access to hormonal contraception by allowing pharmacists to directly prescribe such medications, helping to address disparities for marginalized populations who are more likely to live closer to a pharmacy than a physician's office. This month, Governor Hochul signed a bill that I strongly supported and co-sponsored to provide access to prescription abortion drugs on SUNY and CUNY campuses throughout New York State. And consider the 2023-2024 mental and health hygiene budget we just passed. It safeguards abortion access through electronic data privacy protection by protecting the personal data, including location and history of anyone who seeks abortion care in New York State. And it requires insurers to include recognized abortion medications as part of abortion coverage, even if the FDA does not approve that drug. During the unfounded onslaught of attacks on reproductive rights, we have fought to protect abortion providers, those who provide support and those who seek abortion care, as well as strengthen resources and healthcare infrastructure across New York. Here in New York, we stand ready to respond to any barriers put between New Yorkers and the healthcare that they deserve. Again, I want to thank you for sponsoring this forum this evening. Community Board 8, it's great to see so many friends. I see Elaine Walsh and Brenda Levin and Amy Schwartz and Vanessa and Erica and so many on the forum tonight. I wish I could stay on, but I've got to jump downstairs and get into conference. I still have a package of bills that I want to pass in the next few weeks. And so I've got to run down to conference, but have a good forum tonight. And thank you for inviting me.
And thank you for joining us as always. We appreciate it. Take care.
Thank you.
Good luck.
And our next speaker is law professor Susan Appleton of Washington University, who is a national expert on abortion rights. She will update us on the status of access to mifepristone and what seems likely to happen with that in the courts and or legislatures. So with that, Susan, go ahead.
Can you enable the screen sharing, please? Because I have some slides.
You can go ahead.
Okay. I'm not seeing it. Just a minute, please. I'm sorry. I thought I was all ready. Okay. This should work. Thank you. Can you see it all? Can you see the slide?
Yes.
Yes.
Great.
Mhm.
Okay, so as Assembly Member Seawright mentioned, over half the abortions in the United States are medication abortions. And I'm going to provide a little background to put that in context. In this country, the most common regimen entails 200 milligrams of mifepristone, the drug that's in controversy now, followed by 800 micrograms of misoprostol 24 to 48 hours later. Mifepristone blocks progesterone, so it interrupts the pregnancy. Misoprostol causes the uterine contractions that allow the expulsion of the products of conception. Now, in other parts of the world, 800 micrograms of misoprostol alone are used, with additional doses as necessary to complete the abortion, though there's less patient satisfaction for that. But it does raise the possibility that if even with mifepristone unavailable, misoprostol could serve the purpose. Both of the drugs have other uses. Mifepristone is used to treat Cushing's syndrome and miscarriage care. Misoprostol is used for ulcers, miscarriage care, IUD insertion, and labor induction. The FDA has approved only mifepristone for abortion. Misoprostol, the second drug, has been approved for other uses, so its role in terminating pregnancies constitutes an off-label use, but it has been commonly used in this off-label way in the United States. Mifepristone is more expensive and more difficult to obtain than misoprostol. When the FDA approved mifepristone as an abortifacient in 2000, it attached extensive regulations to it, not applicable to most other drugs, despite mifepristone's high safety record. So providers must be certified specially to prescribe it. Patients must sign a patient agreement form, and only certified providers or pharmacies can distribute it. In fact, the possibility that pharmacies can be certified for distribution only became formalized this year. Previously, only in-clinic distribution to patients who were physically present was allowed. But the COVID pandemic spurred the softening of some of the more demanding rules and paved the way for telemedicine support and mailed abortion pills, which have sparked today's controversy. When the FDA approved medication abortion in 2000, it said that it was safe through 7 weeks gestation. But in 2016, it expanded the approved period to 10 weeks. And today, some providers are offering it off-label up through 12 weeks. And so this is just a little summary of the two different drugs and how they might compare. The legal landscape is very complex. President Biden, as you know, has tried to increase access by having the FDA permit medications to be distributed by pharmacists rather than physicians. But some pharmacy chains have balked under pressure from anti-abortion groups, and some state laws have long made medication abortion illegal. The manufacturer of mifepristone recently filed suit to strike down such state laws on the grounds that they violate the Constitution's Supremacy Clause and its Commerce Clause. The Supremacy Clause argument is that FDA regulations constitute federal law, and federal law trumps state law. The Commerce Clause argument is that states cannot interfere with interstate commerce, that Congress has regulatory authority there. To date, the lower court has held that the manufacturer has standing to bring those claims because it would suffer financial injury if mifepristone were taken off the market. And so that lawsuit is proceeding. In the meantime, though, as Representative Seawright and the introduction by Gail Barron indicated, abortion opponents scored a significant victory with a federal judge in Texas who decided to suspend the FDA's authorization that was granted 20 years earlier. The federal judge in Washington, the same day, reached a contrary conclusion. And so we have these dueling opinions, which cause confusion. And in some ways, that's what those who oppose abortion want. because confusion means that people might be afraid to proceed with their usual medical practices. Now, let me say more about the Texas case, which I believe is the reason you invited me to speak tonight. And I'll be talking about 3 different courts here. First of all, the U.S. District Court for the Northern District of Texas, which was the trial court, the U.S. Court of Appeals for the Fifth Circuit, from which the Texas District Court cases go on appeal, and then the U.S. Supreme Court. So the case was brought in part by anti-abortion doctors and medical associations who could have sued anywhere in the United States, but they chose a district court in Amarillo, Texas, because the one judge in that part of Texas is known to have anti-abortion views, and they got what they wanted. As you heard, that judge suspended the FDA's approval of mifepristone. One big issue was standing. Did the plaintiff doctors and medical organizations have a real case or controversy that allowed them to object to this approval of the law? And what the doctors and medical associations claimed was that they have conscientious objections, moral objections to abortion. They don't do any abortion practice. But because of complications that self-managed abortion care through these drugs might present, they often have to deal with what the judge called unborn human remains when patients who have used these medications present in the emergency room, for example. On appeal, the U.S. Court of Appeals for the Fifth Circuit said that at least some of these individual plaintiffs had standing, and so therefore the case could go on. Others have said that the claims that these plaintiffs are making are much more speculative than real. They're worried about the possibility that they may need to address complications from the use of these abortion drugs when, in fact, the record shows that they are very safe. A second important issue is timeliness. After all, mifepristone was approved as safe and effective as an abortifacient in 2000. Isn't it too late to challenge that? The district court in Texas said no. The Fifth Circuit Court of Appeals said that recent modifications of the safety protocols reopened the earlier approval. So now we should think about the date as 2016 when the FDA expanded the number of weeks the drug could be used. Or we should look at more recent times when pharmacies were allowed to be certified to prescribe or distribute it. And so that court said that the case could proceed, notwithstanding a 6-year statute of limitations. Now, as you know, the case then went to the Supreme Court, which extended the stay on the Texas trial court's order suspending FDA approval, which means that nothing yet has happened, although the handwriting might be on the wall. And the case now goes back to the U.S. Court of Appeals for the Fifth Circuit for a disposition on the merits, and oral arguments are taking place tomorrow. So this is a very live issue as we speak. In the Supreme Court, both Thomas and Alito said that they would deny the application for a stay. And Justice Alito wrote a brief opinion saying that plaintiffs, that those who that the FDA has failed to show any irreparable harm. Now, it's hard to predict how all this will unfold, notwithstanding the fact that we have an anti-abortion Supreme Court, because the current court is also hostile to the administrative state, and the FDA is an administrative agency. So that could have some bearing. On the other hand, the court is pro-business, and drug companies are profitable businesses. So maybe the court's favor for businesses will have a role here. Some of the justices, in particular Justice Kavanaugh, really seems truly committed to a state-by-state regime that would allow patients, even in abortion hostile states, the freedom to travel to welcoming states for abortions without penalties. And I think that Kavanaugh would not want to see the drug availability suspended nationwide. So let me say a few words about one particularly worrisome legal aspect of the Texas litigation. The trial court and the U.S. Court of Appeals for the Fifth Circuit both relied in part on an old federal law from 1873 known as the Comstock Law. Morality crusader Anthony Comstock was the namesake for a range of restrictions at the federal level that not only targeted abortion and contraception drugs and devices, but also banned the distribution of information about abortion and contraception on the theory that such information was obscene and therefore fell outside the First Amendment's protection of freedom of speech. The Comstock Law expressly says that the U.S. mail cannot be used for the knowing conveyance of such drugs, devices, or information. And later, other common carriers were added as well. So, for example, if you're thinking of sending these drugs by FedEx, that would be covered too. Now, of course, the provisions of the Comstock Act fell into disuse once the Supreme Court provided constitutional protection for contraception and abortion in cases like Griswold versus Connecticut, Eisenstadt versus Baird, and Roe versus Wade. But after Dobbs, those cases no longer present controlling authority. And so several provisions of the Comstock laws remain formally on the books. So the question becomes whether or not this dormant law can be used to prevent the access to these drugs, or as Ruth Marcus asks in this op-ed piece, is it still a felony to mail any article or thing designed, adapted, or intended for producing an abortion? And accordingly, there's been a recent resurgence of interest in Anthony Comstock himself. There's been some recently published books about him and his anti-abortion crusade. Now, the Texas District Court, the first court, ruled that the Comstock Law, because it's still on the books, means that the FDA never had the authority to approve medication abortion in the first place because it contravened the old federal statute. But certainly that goes too far because strictly speaking, the Comstock Law only makes abortion pills unmailable. It doesn't make them illegal. Still, if they can't be carried in interstate commerce, no one will be able to have access, and all manner of abortions will be affected because many items used in abortion care must travel through interstate commerce, whether it's through the mail or other kinds of shipping means. The U.S. Department of Justice has said that the Comstock Act refers only to illegal abortions, but it's not clear what that means. So if abortion is illegal in certain states, and here's a post-Dobbs maps of degrees of restrictiveness, does that mean that the Comstock Law applies in those the states that prohibit abortion? Or does illegal refer to federal law? And then we have the FDA authorization. The Department of Justice also issued an opinion saying that the sender of the drugs must intend for them to be used illegally for the Comstock Law to apply. But the Fifth Circuit Court of Appeals said that the statute simply prohibits knowingly sending such items through the mail. Although the court conceded it didn't have to sort out the issues fully, but I think we'll hear about the Comstock Law in more detail in the oral arguments tomorrow. If the Fifth Circuit is correct, it could become exceedingly difficult for anyone to get access to abortion pills, no matter where you live, assuming an effective monitoring system over the U.S. mail and other means of shipping them. Now, of course, the monitoring challenge cuts both ways. On the one hand, it might be impossible to monitor whether anyone is illegally sending abortion pills through interstate commerce. Are all mailed items going to be checked? On the other hand, we've already seen the possibility of surveillance of online activity where messages have been sent directing people to help someone else get access to an abortion pill. And that can land people in trouble. So indeed, many of those seeking abortions today are getting access through the mail via organizations such as Aid Access and underground means. There's a great article in the fall in the New Yorker about the shipment abortion pills from Mexico by expats, and then how they can travel to other parts of the country in the US. Now, although abortion laws have traditionally targeted providers, we're starting to see new legislative interest in punishing those who manage their own abortion care. According to one survey, Oklahoma, South Carolina, and Nevada all criminalize self-managed abortion care. So the natural question is, well, what can we do about this? What countermeasures might we explore? Massachusetts has enacted a telemedicine shield law, and I've heard of a similar proposal in New York. What's unique about it is that it defines the place of care as the provider's location, whereas most laws regulating telemedicine use as their reference point the patient's location. But even so, it's not clear to me at all whether such a law would be effective in litigation brought, say, in a patient's anti-abortion home state, especially if the patient's home state had an express law to the contrary. Why would my state of Missouri, which is very anti-abortion, defer to Massachusetts telemedicine law if we have a law that says quite the opposite, that the site of care is the place where the patient is located? But all of this raises profound questions, not just about telemedicine, but about abortion itself. Where does an abortion occur, and what state's law might apply in any given case? Should we look to the provider's location? Should we look to the place where the first pill that stops the pregnancy from progressing is ingested? Should we look to the place where the second pill is ingested that causes the uterine contractions? Or should we look to the place where the embryonic or fetal remains are expelled? So, for example, if a traveling patient even appears in person in a welcoming state to ingest the first dose, must she remain there for the second dose, or can she take it home with her to her more restrictive home state and expel the fetal remains there? Legislators in hostile states are starting to pay attention to these nuances, even if they have not entirely thought through all the possible permutations. I've seen other suggested interventions explored, stockpiling pills in advance. The Massachusetts governor suggested that Massachusetts was going to do that, but pills have limited shelf life, and having a lot of pills on hand early may not be effective if they're needed later. Some have suggested that individuals could use pills without having taken a pregnancy test in the event of a missed period. That would mean that no one was intentionally terminating a pregnancy, but I'm not a big fan of ingesting drugs when you're not sure you need them. So right now, our best hope, I think, is with the FDA and federal regulation, but we'll have to see how hospitable the Supreme Court is to that. And the other problem is that with a different presidential administration, we could have a very different FDA. So we shouldn't put all of our eggs in that basket. And then I just want to add, and I think this has already been suggested, that these obstacles are going to be much worse for poor and marginalized people, or people in rural areas that don't have easy access to means of abortion, and that is a point that needs to be underscored. So I'm going to stop here. I've probably already taken too much time, but that's a brief glimpse of the legal landscape.
Thank you so much. Our last speaker is Jenna Lauder. Jenna is an Equal Justice Works Fellow at the New York Civil Liberties Union, and she's going to tell us about advocacy efforts that are underway within her organization. Jenna?
Yes, thank you, Gail and Peggy, for having me. So yes, I will close us out by speaking a bit more about some of the work that we're doing here in New York to protect and even expand access to care. And I just, before I get into that, want to say a little bit more about how this case might actually impact us here in New York. We all know that this case arose and is being heard in Texas, but its outcome will almost certainly have an impact across all 50 states. And just to break it down, this is because the FDA doesn't have a mechanism for approving a drug for use in certain states, but not in others. So just to, make it clear, to the extent that a court orders the FDA to take some action regarding mifepristone's approval status or reinstating past versions of the REMS, that change in MIFI status would apply nationwide. And so even here in New York, mifepristone could potentially become an unapproved drug if that's what the court decides to do. And the implications of this would be pretty extreme. As everyone has already shared, but I think it bears repeating, medication abortion using mifepristone accounts for more than half of all abortions across the country. So if access to it is restricted or limited, it would represent really a massive disruption in this already very compromised landscape of abortion care post-Dobbs. And as is so often the case, this impact would likely fall hardest on those who are already marginalized along race, class, age, immigration, and disability lines, as well as those in rural areas, all of whom face, more obstacles when trying to travel to access in-person procedural care. So with, if medication abortion using mifepristone is no longer an option for people, more people will likely be forced to travel to access care in states like New York, straining, not only providers' capacity, but also the capacity of abortion and logistical support funds who, will be called upon to help them in making that trip. Taking mifepristone off the table could also drive up the need for abortion care later in pregnancy, since it takes time for people to plan for travel, both logistically and financially, and can delay their ability to access care. So, I think as I talk about these dire outcomes, I do just want to remind folks what, Professor Appleton was saying, that mifepristone is not the only medication that is used for abortion. And, we have heard from several providers here in New York that they do plan to shift to a misoprostol only regimen if mifepristone becomes unavailable. And Governor Hochul has actually said that New York will stockpile a 5-year supply of misoprostol to ensure that the state has reliable access, if mifepristone becomes unavailable. So, all of that said, there are also providers who may continue to provide the mifepristone that they already have in stock after a decision in this case goes into effect. So that would be, an effort to really extend access to mifepristone for as long as possible. And our understanding is that the risk for providers who continue to prescribe both name brand and generic mifepristone, if either become unapproved or mislabeled, would actually be fairly low under federal law, as long as the provider is providing the medication in state and the patient doesn't intend to travel with it, and as long as the provider complies with the applicable REMS, including whatever REMS are reinstated. So because the federal law risk assessment is low, we at the NYCLU and our partners have been focusing on identifying and mitigating the risk that providers could potentially face under New York state law for continuing to provide stocked mifepristone in the event that it becomes unapproved or mislabeled. And broadly speaking, we are not aware of any provision in New York law that explicitly prohibits the prescription or dispensing of a drug solely because it's not FDA approved. That being said, we have identified several sections of law that seem at least ambiguous enough that they could be interpreted in a way that might expose providers to potential liability. So we've been working with our coalition and government partners, including the New York State Attorney General's office, on legislation that would address these ambiguities and further mitigate any risk to providers. And I just want to note that, this work is largely happening behind the scenes, and I'm not going to talk about the details of this because I think it's pretty obvious. We don't want to highlight, for abortion opponents, the areas of law that they might seek to exploit against providers. So until the bill is ready to pass, we're going to keep it a little bit behind the curtain. But the NYCLU has also contributed to other legislative efforts to ensure that medication abortion in some form after the AHM case is finally decided is still available and accessible. And Assemblymember Seawright touched on some of this at the beginning of the program, but I'll just expand a bit. So in the New York State budget that passed earlier this month, the legislature included language that would protect access to medication abortion via insurance coverage, as well as medical malpractice insurance coverage for providers. So in sort of both ends of the spectrum, protecting patients as well as providers. And so the budget included language that would clarify that insurance coverage requirements for abortion extend to both brand name and generic forms of medication abortion, even if the medication is not approved for abortion care, within certain parameters. So as long as the medication is recommended for use by various sort of medical compendia, including World Health Organization guidelines. And this is, to ensure that private insurance policies cover both mifepristone if it becomes unapproved, as well as misoprostol, which, as Professor Appleton explained, is FDA approved for other uses, but not for abortion. The budget also included a provision to clarify that one of the SHIELD laws passed last June in response to the Dobbs decision, which prohibits medical malpractice insurers from taking adverse action against abortion providers, explicitly shields against adverse action based on a provider's legal use or prescription of an abortion medication, whether or not it is FDA approved for abortion. So those are two pieces that have already passed in the budget. And there is a third bill that actually passed earlier in the legislative session that would ensure access to medication abortion on SUNY and CUNY campuses. And this is not specifically targeted at the CB8M FDA case, but I think will go a long way to ensuring care for, for college students. And so this would require state schools to either provide medication abortion directly on campus or make arrangements to ensure that students can access care through community providers. And Governor Hochul has already signed that bill into law. So in addition to all of these measures that are targeted to medication abortion and the AHM case, which have already passed, there are also numerous steps that New York can and should be taking to shore up our state's abortion infrastructure and not only protect, but also expand access to both medication and procedural abortion statewide. And so these are some priorities that the NYCLU is advocating for before this legislative session ends in June. So our key priority here is the Reproductive Freedom and Equity Fund. This bill would create a sustained stream of funding for providers, as well as abortion and logistical support funds, which is really essential to helping them meet the increased demand as more patients come to New York from other states. And sustained funding, as opposed to one-off grants, is really critical because it allows providers and funds to make longer-term investments in things like hiring new staff, training, expanding facilities, upgrading security, technology, and things like that, which they can't do if they, can't rely on funding year after year. And as we discussed, this is especially critical as we expect to see a surge in demand for abortion care here in New York if access to medication abortion becomes restricted. Another top priority for the NYCLU is a bill that would require hospitals to be transparent about policy-based exclusions of certain categories of care. So policy-based exclusions are denials of care that aren't based in medical science or hospital capacity, but rather on bureaucratic decision-making by the hospital administration. These exclusions currently are often shrouded in secrecy, and patients frequently won't know in advance whether they'll be able to even obtain certain types of care. And this often includes abortion and miscarriage care. So we're pushing for the legislature to pass a bill that would require hospitals to report their policy-based exclusions to the Department of Health, which would then publish it for the public so that they could make informed decisions about where to seek care. And, this is particularly an issue, in certain communities where most of the hospitals are Catholic hospital systems and are more likely to have these sort of policy-based exclusions. Another area where the legislature has actually already taken significant action, but where some additional work is needed, is legislation designed to protect abortion providers, patients, and helpers from both in-state and out-of-state consequences related to their involvement in reproductive health care. So this includes legislation that would protect providers from being subject to professional discipline based on their provision of reproductive health care. The legislature in last June passed a bill that does this for physicians and physicians' assistants, but we need to make sure that this protection is extended to also ensure that advanced practice clinicians like nurse practitioners, licensed midwives, and registered nurses who can also provide abortion care under New York law aren't subjected to professional discipline here in New York based on their provision of that care. This also includes extending the abortion protection laws that passed last session to include the provision of telehealth to patients across state lines. And I know, Professor Appleton, you spoke about a version of this law in effect in Massachusetts. And, you know, you are absolutely right that this cannot fully insulate providers against prosecution by hostile states. But, you know, what this bill would aim to do in New York is to at least ensure that, you know, the machinery of New York, so New York courts and law enforcement, aren't complicit in participating in and facilitating prosecutions or suits in other states. So the package of laws that New York has enacted and which we would extend through this bill to cover telehealth, you know, would prevent New York from extraditing a provider or issuing a subpoena in a case involving abortion care by a New York provider. You know, things like that, you know, while New York can't stop a prosecution in its tracks, we could at least, you know, ensure that we're not providing information that would make that prosecution easier and, you know, throw some sand in the gears. So certainly not foolproof, but potentially a step that we can take. And so lastly, in this tranche of, you know, sort of what I'll call protection laws, we are supporting legislation that would protect data privacy to ensure that people's personal and health data is kept confidential and secure, and, you know, to hopefully, again, in the same vein, reduce the risk that this information could be used against someone who had or performed an abortion as evidence in a criminal or civil proceeding. So that's, you know, much of the legislation that we're supporting this session. And, you know, of course, there's always more. And I am happy to share a link to our legislative memo in the chat if folks want to do some additional reading. But before I wrap up, I just wanted to quickly, you know, reiterate some of what Assemblymember Seawright was saying about the Equal Rights Amendment, which she, of course, sponsored and which passed last session. You know, it's such an important step that New York can take to enshrine abortion protections, you know, in our foundational document. And you know, what this amendment would do more specifically is it would prohibit discrimination by the government based on a person's ethnicity, national origin, age, disability, and sex, including sexual orientation, gender identity, gender expression, pregnancy, and pregnancy outcomes, providing, you know, really intersectional protections within this equality framework. And so now that this has passed the legislature in 2 consecutive sessions, as you've already heard, this is going to go before the people for a referendum vote, and it will be on your ballot in the 2024 general election. So just putting in another plug to make sure that you look for that and don't miss it on the back of your ballot. So with all of that said, I will just briefly conclude by, I think, stating the obvious based on what we've heard today. You know, this is really an unprecedented moment for reproductive rights. You know, not only is care increasingly and aggressively under attack, but the composition of the courts means that, you know, longstanding precedent is, you know, being called into question, and the landscape is continuing to shift very rapidly under our feet. So it's obviously essential that we remain nimble and poised to respond as a state as new attacks and realities emerge. But I also do hope that we can find some thread of opportunity in this moment. And I think the Equal Rights Amendment, you know, represents part of that. You know, this is a moment when we have, when we're really called to reframe the law's relationship to abortion and to bodily autonomy and medical decision-making more broadly, and to push for, you know, more freedom, dignity, and equity than we had before, you know, Roe was a floor, not a ceiling. And so, you know, this is a moment when we really need to be doing more to not just regain what we've lost, but to move the movement forward. So on that hopefully somewhat hopeful note, I will turn it back to you, Peggy and Gail.
Thank you. Let me just ask Jenna, would you mind putting the link that you mentioned in the chat so we could all see that? That would be great. So we now have time for questions and answers. And we will start with the public, and I see that Erica is got her hand up.
Thank you. Professor Appleton, thank you. It's always a pleasure to see you on calls. And I remember when you came to the group last year. I actually have a question for you, but as well as Jenna, because it's about broadly, but also New York. I feel like I'm losing my damn mind. I truly do. I just turned 54 last week, and I thought we were done with this. And I just don't understand. We have laws on the books. I'm not a lawyer, but I've worked in healthcare for nearly 30 years. We have laws on the books for decades that you can't bring a suit unless you have been directly impacted by something. And the plaintiffs in this case have not been directly impacted by anything. How do you bring a suit? It's like the Minority Report. It's like pre-crime. They haven't been impacted by it, but they were allowed to bring a suit, which brings me to the New York side of things. Because if they can bring a suit, why can't people like me do the same thing and saying that our rights are being infringed upon on behalf of my nieces who are 8 and 2 years old, who are going to have less rights than us? On top of that, we all know that when it comes to healthcare, insurance is not equal access. I hear a lot about talking about protecting the providers, which is amazing. But if you have any notion of what's going on every week downtown with the NYPD, SRG protecting protesters and not the women and other people trying to get care at the clinics, it's not matching up. So I'd like to hear from you, Professor Appleton, as well as Jenna on. And then the other thing for New York State, I've known women who have gone through the medication abortion. I've had the other type. I know from working in the pharmaceutical industry that when you move, they couldn't have made this any more difficult. When you remove the first one, it makes the second one hellacious to go through. That's one. And two, having launched, I can't even quantify how many drugs I've launched in my career in the pharmaceutical industry. Drugs are used off-label safely all day, every day, across every disease area. People sitting here right now may not know it, but some of the medicines that you are taking may not have actually been approved for the indication you're taking it for. So where does that leave us with all of the rest of those medications and somebody else coming and saying, I take offense to this medication, I don't want it on the market anymore for whatever it's for?
So I wish I could tell you you're not losing your mind, but I think maybe we all are. I think that we have some judges and justices who are very result oriented. I do think the standing of the plaintiffs in the Texas case is a real stretch. But as I said, they could have sued anywhere in the country, and they picked a judge that they thought would be more welcoming and were able to have a nationwide effect. We'll have to see. The Supreme Court has traditionally been stricter on standing than I think this court is, but I really wouldn't want to predict what's going to happen. I think there are many cross currents here, and I should disclose I am not an expert on standing doctrine, which is very complex. All I know is that I do think these plaintiffs had more of a speculative injury than a real one. Maybe Jenna can elaborate.
I mean, I'm certainly not an expert on standing either, but I completely agree with you. I mean, I think the results in this case were almost a foregone conclusion because of the judge that was overseeing it. And that's obviously not the way that our legal system is supposed to work. Law and science are not currently prevailing in this litigation. So you're right to be frustrated out of your mind. I think, if you read the opinion from the lower court also, I mean, it's you pull your hair out reading that opinion. It's just so extraordinarily offensive and stigmatizing. And some of the, the reasoning that the court uses to support its theory of standing in terms of injury is, in terms of like psychological effects and very speculative harms, it's absolutely absurd. So in any case, it's not helpful, but I agree with you, and it's really frustrating. I think to your other points about protecting, patients in addition to providers, I think New York is trying to do that, and with the insurance, ensuring that medication abortion, as well as abortion more broadly, is required to be covered by private insurers. That is a step geared towards protecting patients. The protection laws also that the state passed last June do explicitly apply to, I use the words providers, patients, helpers, and seekers, because they're designed to apply not only to providers and patients within the formal, medical establishment, but also to people who self-manage their abortions, and also to people who are, helping facilitate abortion access. So that could include institutional helpers like abortion and logistical funds, as well as individuals like, an Uber driver who drives someone to the clinic, or, a babysitter who watches someone's children. So, there are steps that we're attempting to take. I think hospital transparency speaks to this to some extent in terms of empowering patients to, decide where they're going to get care. I think also, the Reproductive Freedom and Equity Fund is really important in providing sustained funding to the abortion funds who are going to be supporting people's ability to access care, and including patients who might need to travel from out of state to receive care here in New York. So I think that's also a critical piece, but there's always more that we can do. And I think the situation with protests outside of clinics is also deeply concerning, and it's legally difficult, when certain rights abut one another, for instance, like First Amendment expression rights coming up against people's rights to access healthcare. Obviously, people should be able to access healthcare without undue interference. And there are both city and state clinic access laws that are designed to effectuate that. But, you're right to recognize that this is it's not currently a supportive environment for patients to access care. And there's a lot more work that we need to do.
Thank you.
Okay, next up we have Alita. Alita, confirm unmuting.
Thank you. And thank you everyone for such an informative and informed presentation. I understood that certain religious leaders whose religions do not prohibit abortion were filing lawsuits on the basis of religious freedom or interference with the expression of religion. And I'm wondering why those have not picked up any steam or seem to have any kind of impact. I'm terrible at names, as Jenna had suggested, there's an abutment or a battering between First Amendment and with the protesters at clinics. And I'm just wondering why nothing else seems to matter in this instance. Thank you.
Do you want me to? I can say a few things, but I'm sure Jenna has more to say. Yes, it's true. Some of those suits have been filed, for example, by people who embrace the Jewish faith, which requires prioritizing the life of the pregnant person or the health of the pregnant person over protection of the fetus. But keep in mind that those would, even if they won, those cases would carve out very narrow exceptions to much broader abortion restrictions. So it might be that one person who successfully sues gets a special exception, but we don't know if it would apply to others. Another approach, though, that considers religion is the basis of a suit here in my state, Missouri, where there is an effort to sue on the basis of the Establishment Clause in the state constitution, because the anti-abortion law in Missouri explicitly uses God language and other religious phrasing to make clear what we all know it is, which is an establishment of religion. So that suit has been filed here in Missouri, and I guess we'll have to see how that plays out and whether it provides models for other parts of the country.
Thank you. I just have one other question,
Well,
which
maybe
is
and maybe Jenna though has something more to add.
sure.
I mean, and I think that was super helpful. I'm not as familiar with the Missouri suit, but I'm interested in seeing how these Establishment Clause arguments play out. I think just one other thing to consider is, you know, I recognize and appreciate sort of the instinct to use every means possible to try to protect access to abortion care, and also to sort of use the tools of your oppressor against them. But I think also what we're seeing in the courts more broadly is this massive expansion of religious rights, you know, at the expense of, you know, anti-discrimination laws and you know, things like that. And so you know, lawsuits that further expand this, you know, First Amendment religious you know, right to be exempt from all kinds of other laws. I think, you know, it's sort of a double-edged sword that we always want to be thoughtful about.
Except for the I also went to law school and spent a lot of time working on First Amendment issues, and there are 2 religious freedom clauses in the First Amendment. So I know this court doesn't particularly seem to, the Supreme Court that is, doesn't seem to particularly believe in them, but this is not a religion discussion, although I think it would be very interesting. But I had one other question. In Montana, there seems to be a lawsuit by young people, again, on the basis of the state constitution, that the state's failure to protect against climate change is causing extreme mental distress against young people. And I'm wondering if because people faced with having an unwanted child or an unhealthy child would face extreme mental distress throughout the rest of their lives, and whether, and I know it's grasping at straws and it's piling argument on argument, but it was such a novel approach that the way the radio talked about it the other day, that I'm just wondering if that kind of thing, that having an unwanted or unhealthy or financially affecting child would have any impact, with whether that would have any traction or not. I don't know if that was clear. Thank you.
Well, I think a majority of this Supreme Court would say, if it's too stressful to rear a child that you didn't want, just send that child out for adoption. There was a lot of adoption talk, as if that would address the problem of unwanted pregnancies in Dobbs. And you know, I mean, the problem is that people who oppose abortion often, but not always, do so or they claim to do so on the ground of fetal personhood. And I just think that for people who embrace that view, to say that it would cause you mental distress just isn't strong enough to justify, quote, the killing of another person. I don't mean to defend that argument, but I think that would be the response.
Thank you very much.
Rita? You have a question, right?
I really wanted to say thank you. This is a wonderful presentation by both Professor Appleton and Jenna. I too am past my childbearing age, but I do have 2 college students, grandchildren. But it isn't only that. My question is, I know it started with Alito, but what gave him the right in the Constitution, where we're all created equal, for him to say that men are more equal than women because they can procreate and whatever it is. It blows my mind that it has gotten to this stage. And are you aware of if anybody is working to overturn Judge Alito's edict?
Jenna, do you want to go first and then I can follow up?
Yeah, sure. I'm sure you'll have a more insightful response than me, but I mean, I think we might be stuck with Justice Alito's edict until we have a new Supreme Court, or at least a new majority on the Supreme Court. And that is the, frustrating reality of how our judicial system is organized. So, and in terms of where he thinks he gets this authority, I mean, if you look at the Dobbs decision, at least, there's a lot of talk about our country's history and tradition. And how the rights in the Constitution must be rooted in our country's history and tradition. And I think what's really disturbing about that is that it, inherently perpetuates all of the, the inequities, the discrimination, racial, gender, based discrimination that we had in this country at its founding. And so, when people say that the Dobbs decision calls into question a whole range of other rights, I think that's what people mean, is that we're going to be, it creates the groundwork to potentially roll back, access to, birth control and contraception, marriage equality, even interracial marriage, all these things that the, court has subsequently recognized as rights in the 21st century.
So we're not all created equally.
Well, actually, see, I think Justice Alito, in rejecting the sex discrimination argument against abortion restriction, was saying he wants to see us all as equal, but doing so requires him to make pregnancy and the capacity to become pregnant invisible. So he sort of puts that aside and doesn't take into account how that can actually influence one's life opportunities. And then it just means that women and men are all treated alike, but without taking into account this fundamental biological difference.
Thank you. So we're not all equal under the law, which is upsetting.
So I have a question for Jenna. You outlined several ideas that you think the legislature should address, and hopefully in this session. Are there any of these that you really think are close to passing? And if so, is there anything that we as a committee should do?
Thank you for that excellent question. So I think, out of the bills that I outlined, I do think that the hospital transparency bill is probably closest to crossing the finish line. I think to the extent that you are able to contact your local representatives, I know that seems old school, but that is often the best way to get these things, on the agenda. At this stage, it's largely about, the competing priorities all vying for attention at the end of session. And so, making phone calls or sending emails to your state senators and assembly members that, citing this bill, citing the bill number, and urging them to pass it can be helpful. So thank you for asking.
Thank you. So we might assume that the others are a little iffy or won't pass.
I'm not going to count them out. We're certainly still advocating for all of them. Reproductive freedom and equity fund really is such a top priority for us. And we have about 3 weeks left in the legislative session to get these things across the finish line. So, we're going to be putting all of our weight behind them. I think in terms of what we're most likely to see, hospital transparency seems the most likely, but we're not dropping anything else.
Can I just ask why the hospital transparency is the most likely to succeed?
Yeah, I mean, I think just in terms of, co-sponsors who have signed on in support, how we, all of the sort of inner workings of Albany, which I will spare you from. But in terms of, having buy-in for a bill like that from the leadership and from the people who have the ability to put it on the agenda, it seems most likely. I think, some of the other bills, either we still have some convincing to do, or, there's a fiscal impact, which is always a little bit harder of an ask.
Thank you.
I'm sorry, Peggy. I also have a question, and it has to do with clinical training. How will doctors be trained if they're in states that do not allow abortions? Because it's more than the medical abortion. It's also taking care of women who have a natural miscarriage. How do you see that playing out?
That is very challenging, and I'm personally worried about it for my own university, which has an excellent medical school that has a history of attracting candidates from all over the country and the world, and now isn't going to be able to provide that kind of training here. But we do, the reproductive justice groups here in the St. Louis part of Missouri have opened a clinic in Illinois just across the river, and Illinois is a very hospitable state, and I believe the training is going on there. But it's not an ideal situation. And I think it will have an impact on attracting medical schools, medical students, medical faculty, and even other people to the region who wants to live in a state that has this political view about women and their reproductive health.
And I will just add that I do know that states, including New York, are thinking about how we can facilitate and make it easier for medical students or residents to travel to states like New York, to access states to receive the training that they need in abortion care. So, I think it's complicated, but there is some work being done to try to address this.
Oh, excellent. Thank you.
So Andrea?
Hi, greetings, everyone. Great presentation and good information. Thank you to the committee and all the panelists. It was appreciated. I want to share real briefly and then ask a question. So over 20 years ago, I had a medical TOP, which is termination of pregnancy abortion. I had to visit the doctor's office for about 2 weeks. They were drawing blood at least 3 times a week. I was literally like a human pincushion. And I was working full time at that time. All in all, I was told there was a problem with the fetus, and I was told that I needed to terminate. So my youngest son at that time was about almost 2 years old. So it was a very hard decision, but I went through with it. So the drug at that time for me was methotrexate. So what I wanted to know, a drug that was used for autoimmune disorders, treatment of cancer, and also for TOP and other things as well. My question is, although this discussion is not about that actual drug, these types of drugs do have dual or more uses that is considered, when, so I want to know with these uses, all of these drugs have, is there consideration with them trying to ban them? Because when they try to ban them, isn't that harming for the other uses as well? I mean, that's, it's a question I wanted to know, because I did see that methotrexate was, about maybe late last year or this year, that was an issue with that, with all of this, these reversals and what they're trying to do. So if anybody could answer that, I hope I explained it pretty good. I hope. Thank you.
I think that's an excellent question. I do think the anti-abortion forces are taking one step at a time. And it's only mifepristone that has been approved as an abortifacient. As we mentioned, misoprostol can be used for that purpose, even by itself or in conjunction with mifepristone, but it's an off-label use. But it wouldn't surprise me to see the off-label uses targeted. And then the question becomes exactly the one you raised. What about all these other conditions that need that require access to those drugs. But Jenna might have more to say about that.
No, I mean, I think that's spot on. You know, I think mifepristone even has other uses besides abortion care. But I think some of the issue, you know, and people have asked and thought a little bit about, you know, well, does that provide an avenue for people to continue to access mifepristone? But, you know, I believe it's a different dosage that's used for, you know, these other types of medical issues. And, you know, it just doesn't really provide a viable path. But, you know, to the extent that that's something that abortion opponents are worried about, I mean, yeah, I guess it seems plausible in this brave new world that they could go after those other uses as well. I'm not sure, you know, how they would frame their arguments in that case, but
right. And even for abortion purposes, most states that have banned abortion do have an exception for medical emergencies. Although everyone agrees that those seem to be very vaguely worded and no one knows exactly when they apply, and patients have had real problems as a result of that vagueness. But that would mean that even mifepristone as an abortifacient has a legal use even in the most restrictive states in some cases. And so a complete ban seems out of the question in a way. And these other uses or these exceptions do create some possibility if the drug is, or if the Comstock law requires the intent to ship the drug in connection with an illegal abortion. Because if you're shipping it for purposes of a legal abortion, for example, a medical emergency abortion, it might be okay. So there are efforts to work with that possible loophole, but the Fifth Circuit said no, it's not intent to use illegally. It is knowingly sending them at all. That's the problem.
Thank
Are there any other questions? I just wonder whether the committee or members of the community board at large have any thoughts about whether we want a resolution or we don't right now, or if anybody has any comments along those lines? No. Okay. So Gail, should we wrap it up or?
I think so. Is there any old business that anyone would like to put forth? And what about any new business? Anything else, Peggy?
No, but Gail and I both want to thank our speakers very much for your wonderful presentation. We learned so much tonight, and it was all really in-depth and informative and very useful information. And thank you to all of you who are attending tonight. We really appreciate your being here.
Thank you for
and my
inviting
thanks
me
as
back.
well. Thank you. And of course, you both were magnificent. And when we have our next reproductive rights forum, do not be surprised if you get emails from us requesting that you join again. So thank you so very much.
Thank you very much, and enjoy your evening, everyone. Thank you.
Bye-bye.
Bye.